Welcome to the third edition of Legal Affairs. I am Lawrence Ma. We all know that in the last term of our Legislative Council, there were a lot of interruptions, such as meetings could not go on because of lack of quorum. People just not show up at meetings so that no business could be conducted. And because of that, bills were dragged on and on. The Basic Law requires that the quorum of LegCo meeting shall not be less than half of all members. That seems to be the root of the problem. Today in our studio we have Professor Albert Chan, who is a senior consultant of the Hong Kong Legal Exchange Foundation, as well as the National People's Congress Hong Kong Basic Law Committee member. Now, Professor Chan, how can this problem be resolved?
Well, the quorum requirement for meetings of Legislative Council is specified in Article 75 of the Basic Law. So we cannot change the quorum requirement because any change in Hong Kong law cannot violate the Basic Law. So it has been a problem in LegCo for many years. And then also with the development of filibuster among opposition lawmakers in recent years, the problem has become more and more serious. Because one of the major practices of filibuster is to ask the LegCo staff to count whether there is a sufficient quorum at a particular moment in time during the LegCo meeting. And since LegCo members often leave the LegCo chambers from time to time, so it is actually quite likely that at one particular moment in time there is not a sufficient quorum in terms of half of the members of LegCo being present. And this problem, in fact, doesn't exist in many legislatures overseas because their quorum requirement is not so rigorous. They only require a quorum, for example, at the time when a bill is put to a vote. Or in some legislatures, they only require a quorum when the meeting of the legislature starts in the morning. And then during the day, there's no need for a quorum. So this problem was resolved to some extent in December 2017, when the Legislative Council amended its rules of procedure to remove the original quorum requirement as far as meetings of the Committee of the Whole Council is concerned. So I'll explain in a minute what is the Committee of the Whole Council. But this amendment, which is an amendment to Rule 17 of the Rules of Procedure, actually allows the quorum for a Committee of the Whole Council to be only 20. 20 members constitute the quorum, even though the whole LegCo consists of 70 members. And this amendment to the rule was challenged in court.
Besides not showing up at meetings to drag things on, opposition legislators had all sorts of interrupting behaviors. If you remember, back in 2016, there was a meeting of the Housing Panel, and at the meeting was the then Undersecretary for Development, Mr. Ma. Long hair, Legislator Leung Kwok Hong, was also at the meeting, and he left his seat, walked to Mr. Ma, and snatched Mr. Ma's folder from him. The folder contained confidential government information. Leung Kwok Hong then passed the folder to another legislator, Eddie Chu, to read. The chairman evicted Leung Kwok Hong and suspended the meeting. Eddie Chu read the folder and eventually returned it to a security guard who then gave it back to Mr. Ma. Now, is there any law that deals with this sort of behavior in the Legislative Council, Professor Chan?
Yes, there is actually a law called the Legislative Council Powers and Privileges Ordinance, which was actually passed in the 1980s. And that ordinance, in particular Section 17 of that ordinance, creates a criminal offense, which is to create or join in any disturbance which interrupts the proceedings of the Legislative Council. Actually, in the case you mentioned, there was a prosecution, the prosecution of Mr. Leung Kwok Hong under this particular provision, Section 17 of the Electoral Powers and Privileges Ordinance.
Because of his interrupting behavior.
Yes, yes.
What did he argue? I understand that he was convicted at trial.
I think the magistrate held that Section 17 is not applicable to members of LegCo.
Right.
So the magistrate actually acquitted him.
Oh, I see.
And then the prosecution appealed by way of case dated.
Right.
To the Court of Appeal. So we have a decision, a judgment of the Court of Appeal, which was then further appealed to the Court of Final Appeal. So in fact,
right.
This case raises what the court considered to be important legal issues, so that it went all the way
to the CFA.
Yeah.
Now, what did they argue at the appeal? What are the issues?
So one crucial issue is whether this section 17 of the Electoral Powers and Privileges Ordinance applies not only to ordinary members of the public who create disturbance and interrupt legislative proceedings, but whether it also applies to LegCo members. Now, it was argued, Leung Kwok Hong, even if there is such misbehavior on the part of LegCo members, they should only be subject to the internal disciplinary proceedings of LegCo, and the courts should not interfere.
Instead of a criminal charge.
Yes, so they say that the court should not have criminal jurisdiction to try a LegCo member under this section of the Electoral Powers and Privileges Ordinance. And they also rely on two other legal provisions. One is a section in the Electoral Powers and Privileges Ordinance, which is Section 3, which protects the freedom of speech and debate of LegCo members. And they also rely on an article in the Basic Law, I think it is Article 77, which also provides immunity for statements made in LegCo. So they argue that, well, because these provisions are on freedom of speech and debate and immunity and so on, and they also argue that the manner in which freedom of speech or freedom of expression is exercised is also protected, and they argue that Leung Kwok Hong's behavior is covered by this provision.
So what they're saying is Legislative Council has a constitutional right of freedom of expression inside chambers. So what and that sort of disruptive behaviors is part of freedom of expression. That's what they argue.
Yeah, it's part of the manner of expression.
Right.
And there is some authority saying that the manner of expression is covered by freedom of expression.
So it's not just the utterance, because of they have Leung Kwok Hong actually snatched the folder.
Yes.
That's the manner. So what did the court say then?
Well, the
Court of Final Appeal.
Yeah, both the Court of Appeal and the Court of Final Appeal were in agreement in this case in dismissing Leung Kwok Hong's argument.
Right.
So basically, they held that Leung Kwok Hong's behavior in this particular case did not fall within freedom of speech or debate. So the court said that, well, we have to draw the boundary of protected freedom of speech and debate. So what Leung Kwok Hong did in this case, snatching the folder and so on, the court said that it is nothing to do with, or it is outside the scope of freedom of speech and debate. And the court also said that the Electoral Powers and Privileges Ordinance, in creating the offence of contempt of LegCo, which is to create disturbance, interrupting LegCo proceedings, the ordinance was intended to apply to everybody. The ordinance was not intended to give any exemption or immunity to LegCo members.
Right.
Yeah.
So the legal principle is that legislative councillors would have no privilege if they have acted in a disturbance manner or in interrupting manner in chambers.
Yes, yes.
Thank you, Albert. And this is the program for today. And thank you for watching Legal Affairs. See you next time.